Got it. Thank you, guys. All right. If there's a glitch with the slides advancing, just give me a holler, and we'll see if we can get things back on track. So my name is Sammetria Goodson, and I am the managing attorney for Goodson Law. And this title of this presentation is Contracts in the Time of COVID-19. It was originally Contracts in the Time of Corona, but I think that with educating myself, I realized that coronavirus has always been around, but this novel coronavirus is COVID-19. And so what we will do is just walk through some contract terms and the importance of contracts. So thanks, Adrian, for teeing that up. But really what we want to do is make sure that you guys have a framework for how to think about contracts and why they are important and some things that you can think about moving forward. So again, my name is Sammetria Goodson. I am the managing attorney for Goodson Law, and my firm helps artists, creatives, designers, performing artists, makers, tinkerers, all those folks, creatives broadly speaking. We help start, protect, and grow sustainable creative businesses. So we focus on making sure that we support creatives and artists through the entire creative business life cycle. Where that falls in terms of industries is art and entertainment, fashion and beauty. We represent clients who are lifestyle brands and influencers. Certainly that includes design professionals and folks who are on what I would consider to be the cutting edge, the new media folks out there. And we are a transactional practice in that we focus on intellectual property, we focus on contracts and licensing, but I also have experience in litigation, so we help resolve disputes. Sometimes those disputes include contracts and sometimes they don't, but we do both. We're both a litigation firm as well as a transactional firm. So I have an office here in Dallas, and in the midst of COVID-19, I also, right before everything kicked off, I opened my office in Philadelphia. So I'm right along with everyone else who had kicked something off for the beginning of this year and had to shift very quickly in the wake of COVID-19. So just a little bit about me. I am an attorney, I'm an art lover, I'm an advocate, as well as a collector. So I tend to come from the world of art from many different perspectives. I was born and raised in Houston, went to school in Austin, lived in California for a little while, also lived in Jersey for a while, lived in Philadelphia for, I would say, the better part of my late 20s into my 30s, and then I came back home to Texas, like Texans do, and landed in the Dallas area. Also, for my background, I studied business in the Combs School of Business at UT Austin, and at the same time, I studied art history in the School of Fine Arts, also at UT. And my thought there at the time was that I was going to work on the commercial finance side of the art world. So I was interested in commercial finance, and of course, I saw myself in Sotheby's or Christie's in Paris and London. But as things would have it, I decided to go to law school instead, and I decided to go to law school to practice art law, which way back when I went wasn't technically a practice area. There were some attorneys out there who were providing legal services to the art market. There were a couple of books that were out there, one or two case books out there, but art law as we know it today really didn't exist. And so it's just been my pleasure to be able to work with artists and support artists as the market has changed, as the global art market has changed. In terms of my experience, I bring corporate marketing and sales experience as well as clerkship. I was a judge's attorney for 2 years, so that helps with the litigation side. Like I mentioned, I was a litigator, did some plaintiff side work where I tried cases to jury verdict, and now I do mostly transactional practice at Goodson Law. So that's about me. So in terms of topics of discussion, here are 6 things that we're...
Sammetria, I am not seeing your screen advance. Are participants, can you advance a slide, Sammetria, and see?
Here, let me,
Sorry. Just want to make
No,
sure
no
we're
problem.
doing
No, thanks for
everything.
bringing it to my attention. Yeah, let me try that again. Let's see.
Okay, cool.
All right, how about there?
Yeah, all right. Now I see topics of discussion.
Okay, all right.
And then if
So
you move
yes,
forward one, do you want to move forward one real fast just to check?
Yeah, I did.
I'm still on topics of discussion. Oh, no, now it works. Oh, well. It seems to work when you like move out of presentation mode.
Yeah. Let's see here. Hold on just a minute.
Of course it was working earlier when
yeah, of course. All right, let me try this one more time. Okay, how about now? We're advancing now?
Yep, there you go. All right, proceed.
All right, let's go
Sorry
back.
to interrupt.
No problem. No, thanks for letting me know. All right, here we go. These are the 6 topics of discussion. So actually, we already did the introduction and the background, but I wanted to start with a potentially existential question, which is why contracts, why now? Then take us through an overview of the legal system and how contracts fit into the system that we already have. I think this is really important, and I find that when my clients have an understanding of kind of where contracts fit and how they fit into the current legal system, it helps them to think about how they enter into relationships and how they enter into agreements. Then we'll go through the anatomy of contracts, and this is where we will discuss the types of clauses that are in contracts now that people are very interested in the wake of COVID-19. We will go through a real life COVID-19 example. I have an asterisk by real life because it's actually a couple of different things that I'm helping clients with sort of spliced together so that we can maintain confidentiality. And then I'll give you just some simple ways that you can protect yourself, and we'll go through some questions. So why contracts and why now? So in the wake of COVID-19, as I mentioned, there are a lot of questions about contracts and contract terms. There's also questions about what to do when you don't have a contract. So just to give you a kind of a bird's eye view or some insight into the types of issues that I'm helping clients with right now and what we're seeing in the art market from my colleagues and just broadly speaking in the industry is that we see a lot of artists who are applying for relief and applying for business support. So myself, as well as my colleagues who are accountants, have been very busy helping our clients answer the types of questions that are needed that are being asked so that the artists can receive some of the relief funds and some of the benefits. Some of those questions have legal implications, and some of those questions are from an accounting perspective. But what we've found is that for the artists and creatives and freelancers who kind of walk through steps to set up their businesses or set up their structures prior to COVID-19, they're having like an easier time getting through the application processes versus the ones who really didn't, and they're having to rely a lot more heavily on mostly the accountants and CPAs out there to help them get the information that's being requested for the application to obtain relief and to apply for those programs. So artists and creatives are very busy with applying for relief and business support, the loans, all of the different forms of financial support that are out there related to COVID-19. And Another thing that artists are doing is that they are reviewing their existing relationships and they're identifying areas of risk. And so what I mean by that is they're sort of taking a look at all of the projects or contracts or things that they had for the rest of the year, anything that they had coming up, obviously, since February and March of this year. And they're taking a look at what they have and they're looking at contracts and seeing what they can do to either get out of the contract or to enforce the contract, depending on your perspective. But they're also taking a look at existing relationships that may not necessarily be impacted, meaning, for example, I have a client that is in the marketing and advertising space, and the deliverables that my client gives to their clients really can be done online. You don't really have to be in the studio or the office to provide the service. But what they're doing is they're looking at their existing contracts and they're saying, well, wait a minute, what do we need to do to change some things? Can we renegotiate some terms? Because they're preparing for the future. So there's a lot of that now with artists taking a look at existing relationships. Also, they are seeking help in interpreting and evaluating their rights under agreements. So as we all know, there's a lot of different events, a lot of work, a lot of business, a lot of things that have been canceled for artists and for creatives. And so I've been spending a significant amount of time reviewing contracts and helping clients walk through what they can do in response to what has happened with COVID-19. And then lastly, artists are tweaking their existing policies and procedures and preparing for the future. The last part of this presentation, I'll offer some thoughts on where I think this will go in terms of litigation, but people are taking advantage of the time right now to prepare for the future. So I just wanted to throw that out there as something positive maybe to think about in the midst of all of what's happening, that this is an opportunity to think about how you can start maybe putting in place policies and procedures or contracts, or putting in place the type of things that will help you be sustainable and build resiliency in your art practice over time. So there's a silver lining that you can accelerate maybe planning for the future in the wake of COVID-19. But in terms of the question of why contracts, why now, the spoiler alert here is, from my perspective, contracts always, right? Contracts pre-COVID-19, contracts certainly now in this current situation, and certainly the importance of contracts later on. From a legal perspective, my thought about whether you should have a contract or not, or how you should interact with them, doesn't really change, because contracts are actually written and meant to deal with disaster. They're meant to deal with situations that go off rails, right? They're meant to deal with situations and circumstances that are out of control. And that is the biggest thing that I'd like to get over to you guys today when we look at contracts. Is there's a certain way that attorneys and business people look at contracts versus the marketplace, right? Versus artists, versus the folks who are on the other side. So it's not that COVID-19 is making it a situation where you have to have contracts now. It's not like anything has technically changed that much in the wake of COVID-19. It's just that disaster has actually happened, and now people are furiously going through their contracts, skipping to the last pages to try to figure out if there's anything in there that helps them with this current situation. So I've been a proponent and an advocate of contracts, as Adrienne teed up, prior to the situation that we're in now, but it's a window through which we can look at things a little bit differently. So before we deep dive into that, I did want to pause for a minute and talk about the creative business life cycle. And the creative business life cycle is sort of how I work with my clients to plan for and think about what they are doing from a strategic level in terms of their art practice. So it follows these steps, which I have summarized into 4 steps, but essentially it's the creation stage where you're generating ideas, you are deciding whether to move forward on any of your ideas. It's the stage where, after that, it's the stage where you are building, you're establishing a foundation, you're investing in your infrastructure. From there, you go to maybe protecting what you've created. That is, you are identifying and mitigating risk. These are all heavy legal terms, but I'll sort of flesh those out in a minute. And then from there is growth, right? And you can have multiple streams of income in your artistic practice. You could have multiple projects that you're working on. You could have multiple businesses that you're running. No matter how many different streams of income or how many projects you're working on or whatever you're doing, you're still sort of following this timeline, in that you're creating, you're building, then there becomes a point in time where you're protecting your creations, and then from there you are pursuing growth. And so from my perspective, as an attorney, every point on this creative business lifecycle is a point where contracts are important. So again, a contract, the thought of it is, it's not just a sheet of paper that you have once you finish a deal. Contracts sort of operate in the background and underneath. They're like the undercurrent, if you will, of a lot of what we do on a daily basis. So in the creation stage, obviously confidentiality agreements and NDAs can become important. So those are contracts that protect your ideas against them being stolen or you being taken advantage of in the creation stage, right? This is where you're ideating, this is where you're collaborating and you're talking to people. So contracts kind of show up there. Certainly when you're building your creative practice, you're building a foundation, you're maybe establishing a business, you're getting your policies and procedures in place, those also involve contracts. So you may have an LLC that you have with yourself and a collaborator. Filing the LLC is one thing. Having an operating agreement that manages the relationship and discusses who's supposed to be doing what, and most importantly, what happens if those things don't occur. The operating agreement is what's important for the LLC formation, not necessarily filing at the state. So contracts show up there, certainly from a tax perspective, in the sense that you are filling out forms in a way, the way that you work through planning for tax purposes, there's contracts involved there. When you get to the protection stage, we're talking about intellectual property, and we're certainly talking about agreements there where you may be working with contractors, you may be providing services to other people, and you want to protect your IP. So contracts show up there. And absolutely in the growth stage, as you're growing your artistic practices, the more you grow, the further you get along in the creative business life cycle. Policies and procedures become important, and thinking about your strategies and what will happen in terms of any sort of pre-litigation and litigation. So if, as the saying goes, if you're in business long enough, you may have to deal with these types of issues. But I wanted to, again, give us an idea of the different places where contracts and agreements become important, and it's throughout the life cycle of your business and your artistic practice. So artists and creatives' rights is one of my favorite topics. I'll go ahead and tee up all of the elements of this slide. I absolutely love talking about artists' rights because I think it's important to empower artists, and I think it's important that artists know that there are various places within the United States legal system and even the international legal system that provide protection for artists. One of the reasons that artists tend to get taken advantage of is because they don't think that there is any protection out there for them. And because of that, it causes them, even on a subconscious level, to enter into deals or to agree to terms or to not negotiate. There's a lot of things that happen psychologically when you don't think that you have the power to negotiate, or you don't have the power to enter into agreements with some level of equality and equity. So I love talking about artists and creative rights. I could spend all of our time today talking about this, but I did just want to bring up this slide so that you have an understanding that there are rights that artists have that are gleaned directly from the United States Constitution. At the federal level, there is statutory law. Statutory laws are laws that are passed by various legislatures at the state and federal level. Depending on which state you are in, there may be more robust laws that you can avail yourself of at the state level. California and New York have very robust laws that are passed specifically for artists. You also have common law. Common law is the law that's created by judges on a daily basis. It's the law that governs relationships. It's the law that's created in the midst of court opinions and court judgments. So it's not necessarily law that comes from the Constitution. It's not necessarily law that's written down in a book somewhere like the statutory law. There are legal principles underpinning our legal system that are fleshed out in the courts on a daily basis. And then there's a lot of different ways that artists and creatives can protect themselves via the common law that exists. And of course, our topic for today is that there is contractual law. And what I'd like to do is talk about contractual law in a way that's a little bit different than maybe what you've thought about, a different way that you thought about it before. So for constitutional and statutory law, you have federal law, which governs copyright and trademark. That's important for artists to know about. Again, you have state law. Different areas of state law on the statutory level that are important for artists are property law, trust in estates become important, organization laws like business law, and there are art-specific laws. For instance, the state of Texas has something called the Texas Consignment Act, which is an act that protects artists who've given their work to galleries, and the galleries may be in a bankruptcy or a negative financial position, and this law protects the artist's work from the gallery's creditors. So there is art-specific law that has been promulgated by the various legislatures of different states. Going towards the middle of the slide here is case law. So this is the common law that I was talking about on the slide before. These are the legal principles that are sort of the undercurrent or sort of the underpinning of our legal system that artists can avail themselves of. There's tort law, which governs relationships. This tort law essentially says that there's a way that people should treat each other. That's the simplest way to think about it. There's a way that people should interact with each other, and that has a certain standard. And if you fall below that standard, then the law says that you may have, or the other person may be liable, and then therefore you may be able to be compensated for that failure. So there is tort law, and also what courts do is they interpret statutes and they also interpret contracts. But I want to focus on this column to the last column that is entitled self-created law. So essentially contracts are self-created law. What does that mean? That means that when you and the other party put a contract together, it is your ability and your opportunity to come up with your own definitions of how that relationship will work, how it will not work, and what happens when people don't do what they said that they were going to do. It's your own law. It's you creating your own template for how you're going to interact with the other person. And what's wonderful about this is that the courts will enforce your self-created law. So the idea is that a contract isn't just, a sheet of paper. That a contract and what it's meant to do is give you an opportunity to come up with your own self-created system of how you're going to interact with someone and how they're going to interact with you. And the courts will enforce it under certain parameters. So that's what contracts are, the policy, the philosophy, if you will, behind contracts. Of course, it includes the parties, important dates, talks about an exchange of value for services. There's also payment terms, breach and damages. These are all the sorts of things that are common within contracts. But again, I want to emphasize this idea that a contract is your ability to come up with your own system of how you're going to interact with someone. And that's beyond the sheet of paper that the contract is on. So let's move on to the anatomy of contracts, right? So I like myth busters, and so whenever I can find myths, I like to participate in a little bit of myth busting. And so these are common things that I hear when I talk to clients or just people in general about contracts. So they think contracts are for the rich and famous or celebrity artists, right? They think that contracts are what artists start entering into when their work starts selling at a certain level. They think contracts are what you get when you have a lot of money, for instance, because they think they may be expensive. So some people think that contracts are a waste of time. They think that they're a waste of money, or they think that they're a luxury, again, something that you have when you have a lot of resources. The third one is very common. Even if people don't say it out loud, this sort of operates in the subconscious, is that they think contracts are a hindrance to the deal. They think they're a hindrance to getting the work. They think that they're a hindrance to getting paid because in some industries, like the art world, there is still some people that operate on like handshake deals. I think post-COVID, we might not be doing handshakes anymore, but the idea is that it is very prevalent that people enter into relationships and enter into contracts on a daily basis without there being anything written down anywhere. And the idea is that you're trading off of trust. This person is giving you their word that they're going to do something. You give them your word that you're going to do something, and then that's how business is done. So I wanted to address this here because I know that, within the art market, this is very prevalent, right? And there is a lot of business that gets done this way. But sometimes people will think, even again, subconsciously, that once you start talking about contracts or once you try to get someone to sign a contract, that all of a sudden the deal will disappear and the other person will go, do something else, or they won't get the opportunity. So another myth is that contracts are magical sheets of paper. This is one of my pet peeves, but what I mean by this is that sometimes people will think about and view contracts as if, like the sheet of paper, so here's my demonstration, that this sheet of paper and the fact that it exists is what will inoculate them against, or it's the thing that will sort of make all problems go away. And so what I mean by this is you'll have people who will have extensive conversations, both parties, extensive conversations. They'll go to coffee 8 times, talk about what they're going to do, and then at the end, someone will go and pull some form or something off of Google, put their names in it, and then check some boxes, and then they'll slide it across the table and sign it. And they think, aha, we have a contract, everything is good. So I say, no, everything is not good, because the existence of the sheet of paper is not where you have protection. It's what's actually on the sheet of paper. And it's also what you've negotiated before you memorialize your agreements on the sheet of paper. So they're not magical sheets of paper that if you just have it and it's filed away somewhere that it means something. You actually have to go through the process of trying to negotiate the contract, or at least make sure that the contract represents your actual deal. So what is a contract? I will tell you that in law school, for first-year law students, there's an entire semester spent answering this question, essentially. And at least the first 2 weeks of class are spent answering the question, what is a contract? I have tried to distill all of that to this one slide to give you just the highlights, but it's very important to understand what is a contract, because contract is made up of a few elements. And the elements are an offer, an acceptance, consideration, mutuality, and capacity. So what does that mean? Essentially, a contract is someone offering to do something or to sell something or to give you something. It's them making an affirmative expression to say they want to do something or give you something. Acceptance means that you reciprocate and you say, okay, I accept whatever is being offered. Consideration actually is a it's kind of a complicated concept, but essentially consideration means that there is an exchange of value for the agreement. Mutuality means that there's some sort of equity between the parties, or there's some sort of equity within the deal itself, the terms of the contract. And capacity gets to this idea of the parties having the capacity and the ability to enter the agreement. So mutuality and capacity deal more with what happens when there's some sort of inequity or inequality amongst the parties. For instance, there are some people that the law has deemed cannot enter contracts because they don't have the mental capacity to do so for various reasons. But essentially what it boils down to is a contract is an offer and acceptance, and there's some exchange of value for the offer and acceptance. Another way to think about it is that a contract is an agreement between parties that creates mutual legal obligations. So again, it's mutual. It's not just one side. It's often not just one-sided. It's a mutual legal obligation. Another way to think about it is it's simply an exchange of promises in exchange for a benefit, and it's an agreement to perform a service or provide a product. So when you think about contracts this way, it's interesting because when you take the concept away from like a sheet of paper, what you realize is that you actually enter into contracts all the time. You enter into contracts all the time. Whenever you agree to do something, if someone offers something and you accept it and there's an agreement and there's an exchange of some sort of value, and the value does not have to be monetary, you are entering into a contract. So contracts pretty much are made and breached and broken and entered into on a daily basis. But one thing I wanted to get across today was that the contract, what it really is, it is the thing that exists after you come to an agreement. Again, the contract is not something that you grab a form for and fill out some spots or blanks on the form, and then that's the contract. That's not a contract. That's a sheet of paper with words on it that has like contract in the title. An actual contract is a representation of an agreement that you have come to with the other party. This is exceedingly important in this COVID-19 world, because what we are seeing is that people, like some of my clients, are coming to me with contracts and they're saying, hey, can you help me interpret this contract? What can I do? What can they do? What are my rights? And the contract itself is completely divorced from the actual deal. The contract itself has nothing to do with the work that the client has been doing. The contract doesn't account for any of the things that would be of interest in the situation like we have right now. And the reason those contracts exist is because the parties weren't understanding that the contract is not the paper, it's not the words on the paper, it is the manifestation of the agreement that you've come to. And so there are people that even have contracts, the physical contracts, they have them, but they're not much help to them right now in COVID-19 because they didn't think about making sure those terms were even representative of what they are currently doing. So that is Contracts 101 distilled in like a couple minutes, but again, the concept of contracts and studying how they work and how attorneys really work to help their clients enforce contracts is very complicated, but essentially this is what it boils down to. So let's talk about some key contract terms. These are the ones that usually are on page 1. So if you do endeavor to read a contract, you usually will get through these terms because they're the terms that appear on page 1 and 1.5 or 1 to 2 of a contract. But it's the who, what, where, when, why, and how. You know, it's the parties, what are they doing, where are they located, when are they supposed to be doing whatever they're doing, how are they going to do it, and why. When you see recitals in a contract, the recitals are trying to get to, you know, why are these people even, why are the parties even coming to an agreement? Like, what is it about the parties that would cause them to want to work together? That's what the recitals usually cover. You also have payment terms and payment schedule. That's usually, that often shows up within, the first part of a contract before you even get to the fold, if you will, on the document. There's some payment terms and payment schedule, which is really important. And again, the idea is that the key contract terms are actually supposed to summarize your agreement, your actual agreement. So to give you an example of that, if you're an artist and you are commissioned to do a sculpture, somewhere in the basic terms, it should actually say that you were commissioned to do a sculpture made out of these materials, which should be delivered on this date. It gets very specific in terms of what you are actually doing. So there's usually a summary of the services or the goods or whatever the purpose of the contract is. And then some key contract terms are the ones that folks are looking at now, which is what happens when things go sideways. So I was thinking a couple of different ways to describe it, but it's when things go sideways or when things go off the rails. What are you looking at? So some key contract terms would be dispute resolution. The dispute resolution terms usually show up on page 3 or 4 if we're talking about a 5-page contract. And dispute resolution deals with what happens when actions are taken by parties and there's no other reason that they should take those actions. So it's breaches of contracts, and there's usually a procedure for resolving those disputes. And then there are what we're going to spend the bulk of our time discussing today, which are the boring terms. These are the terms that people skip over. They appear on page 5 or 4 or 5 if we're looking at a 5-page contract. There's the terms that are at the very end of the contract that most people, they'll look at payment, they'll make sure the parties are correct, and then they'll skip through that and go to the end and sign the contract. Most of the stuff that people skip over are the boring terms. And again, those are the terms that people are looking at right now in COVID-19 because it deals with circumstances that are out of the party's control. So when you think about the anatomy of a contract, again, the first part deals with the specific deal. The second half, if you will, and in some contracts, the bulk of the contract deals with what happens when things don't go according to plan, and specifically what happens when there are circumstances outside of the party's control. So let's look at some of those boring contracts, and there's 2 of these slides just to give you a roadmap of where we're going to go from here. But to orient us in this idea of the boring contract terms, I found a photo of me in a law library with my laptop and my folder for my legal pad, searching through a book to find an obscure description of a term for a case that I was working on, which required me to go to the library. So it was the most applicable photo that I could find to help us talk about these boring contract terms, which are super important right now. So the first one is force majeure. So if you've read any articles or looked at anything, every industry, this is not just specific to artists or creatives, but everybody, every industry is looking at force majeure clauses right now. What force majeure is essentially, it is the clause that gives the parties permission not to perform under the contract due to certain circumstances. So again, it is the provision that allows you to not do what you say that you were going to do, or it allows the other party not to do what they said that they were going to do, what they promised to do. It gives them kind of an out from doing that. Often, force majeure clauses will have a principle or legal term called act of God, which is very interesting. I won't get into the history of that, but act of God clauses in Texas, of course, are things that happen without human intervention. So the natural disasters tend to sort of fall in the act of God category. Now, what's interesting about COVID-19, which we'll see if there's any litigation about this, but the way that Texas courts interpret the act of God clause, of course, they will consider any human intervention to be outside of the force majeure clause in most cases. And COVID-19 is interesting because it's passed by human transmission, and in terms of some of the events that have happened, it's due to human closures, right? It's people making decisions to shut things down. So it'll be interesting to see, you know, how various courts, but for our purposes, the courts in Texas deal with this. But force majeure deals with things that are called act of God and pandemics or epidemics. And so a lot of the force majeure clauses account for epidemics, but not necessarily pandemics. So again, I know as a lawyer, I kind of nerd out about stuff like that, but I just wanted to bring that to your attention, that those are the types of things that are in the force majeure clause. And the other really important part of force majeure is that it usually accounts for governmental acts and orders. So when the government shuts something down, when the mayor says that you can't do something, or when the county judge says you can't do something, or the governor, or, you know, a governmental agency, those types of actions, those governmental actions may trigger the force majeure clause. There's also contingency clauses and extensions. So those are often in contracts, and those give parties extra time to perform under the contract. The idea is that the contracts that have these terms build in kind of some elasticity to account for things not going on schedule. And so they actually give timelines and time limits in a way for the parties to get their relationship back on track, or get the performance of the obligation back on track without it resulting in some sort of breach. And they're called contingency plans or extensions. So a lot of people are looking through their contracts to see if there are any terms that give them some leeway so that they can maybe negotiate for an extension, or there's some sort of contingency built into the contract. So those terms, which are often overlooked, are again being scrutinized right now to see what sort of relief people can get. Termination and cancellation clauses are also important. There's a difference between the two of these, but essentially it gives the parties the ability to end the contract under certain conditions, and often there's a notice period. You have to actually give the other party notice that you intend to terminate, and then there's often a procedure that's within the termination or cancellation clauses. So the difference is, when you terminate a contract, usually you're terminating the contract for reasons other than a breach, meaning you're terminating the contract for reasons that have already been thought of or already accounted for. And sometimes there's automatic terminations after a certain period of time. Let's say, so you have a contract and you're supposed to be providing some sort of service. You know, after a certain period of time, the contract may automatically terminate. Of course, to get out of an automatic termination, you would have to have an automatic renewal. But terminations are clauses that deal with circumstances where the parties have already thought about, okay, how do we get out of this? Like, how do we just end this contract amicably? Cancellations are different. Cancellations usually account for situations where the other party has breached or they are in default. So if we go back to the idea that a contract is an offer, an acceptance, and consideration, and it's a set of promises that people make that are mutual, when either side doesn't do what they said they were going to do, they are in breach of the contract. You want to avoid breaching a contract because that is when your liability sort of skyrockets, right? That's when the possibility that, you know, you'll get sued, or the possibility that you'll, you know, have to end up paying a bunch of damages, things like that. Those tend to skyrocket when people start breaching the contract. Breaching a contract, again, means you just decide you're not going to do what you said that you were going to do for whatever reason. Oftentimes, cancellation clauses include liquidated damages, which is a fancy way of saying if you cancel the contract, you have to pay a certain amount of money, and those are oftentimes built into the contract. So people are very much interested in cancellation clauses because right now, if an event is canceled or work that you have is canceled, they're looking to see whether or not the cancellation clause actually includes an amount of money that you can get when the other party cancels. So again, these are things that you typically think about prior to something happening, but I did want to give you guys an idea of the various terms that people are looking at right now in this COVID-19 world, but also why they are important. So again, these are the things that people that are usually at the end of the contract and people gloss over them. So just a few more boring contract terms. These are ones that people are more familiar with, but essentially indemnification, right? That means an indemnification clause makes it a requirement that one party compensate the other party for losses due to a breach, due to disruption. There's a number of reasons where an indemnification clause kicks in, but it has to do with litigation. It has to do with who pays for what when there's a loss incurred. And oftentimes the indemnification may be mutual. So I typically get contracts where it's a one-sided indemnification clause, and I tend to negotiate a mutual indemnification clause, or rebalance the power, if you will, in contracts. I tend to help my clients do that, and sometimes it's negotiating the procedures of the indemnification provision and the parameters of the indemnification clause. Limitation of liability, there's often, you'll see those clauses in contracts. That's the attempt of the parties to limit whatever liability there is. So you may see a dollar amount. You may see something that says, all right, if everything goes awry and we all go to court and there's a judgment, no matter how much the judgment will be, the only amount that you'll get is X, right? And sometimes you'll see a dollar amount, or you'll see a percentage over the value of the contract. You'll see something there that's seeking to limit the potential exposure if there is liability. So that's limitation of liability. And insurance clauses are important. I see a lot of insurance clauses with my clients who are artists who are doing large-scale public art. There are typically requirements by municipalities and the folks who are making the commissions that the artists front the cost of insurance. And the reason is because insurance deals with specifically what happens when things go awry. So if you have the correct insurance policy with the right limits, you may be able to sort of avail yourself of those policies. So right now what people are looking at for insurance clauses is they're looking in their agreements and they're trying to see, was the other party supposed to have insurance for this particular contract? And if so, what is the procedure for seeing if I can avail myself of their insurance? So people are looking at insurance clauses now to see if there's any coverage there so that they can make a claim. So those are the boring contract terms. So for kicks, I went and pulled a pretty robust force majeure clause. So I don't have an example of all of these clauses. Again, the idea was just to describe them to you high level so that you know what they are in the contract and why they are important. But this is the force majeure clause, and it essentially says that the company is not liable for not doing what they said they're going to do under the contract. And I highlighted some words here that are, important. So they won't be liable either directly or indirectly. And then we see this phrase, by circumstances beyond their reasonable control, right? So again, the idea is there's a set of contract terms that deal with situations that are beyond your control. But take a look at how they describe it. They describe these circumstances as being acts of God. Then they say earthquakes, fires, floods, wars with an S, civil or military disturbances. What are those? Acts of terrorism, sabotage. The sabotage was interesting, so that's why I picked this one. Strikes. You see it says epidemics, right? Not pandemics, but epidemics, riots, power failures, or computer failures. And then it goes on to say loss or malfunction of utilities, transportations, computers, hardware or software, telephones, accidents, labor disputes, acts of civil or military authority, governmental actions, right? So these are governments perhaps closing down certain businesses due to COVID-19. And they also then added the inability to obtain labor, material, equipment, or transportation. And the only provision that the only thing that the company has to do in exchange for this force majeure is that the company is required to use their best efforts to deal with any of these things. So I pulled this as an example of probably one of the more robust force majeure clauses, just to give you an example of the types of things that you'll see listed. Now, I will say in Texas, and each state law is different, right? So I'm licensed in Texas and licensed in Pennsylvania, and the laws of the various states could differ in terms of how the courts deal with these clauses, but Texas is very clear that if you do not have a force majeure clause, there's nothing within the common law, there aren't any sort of general principles that you can avail yourselves of. It has to be in your contract. So there are a lot of people who are a little brokenhearted that they're looking in their contracts and they're looking for something like a force majeure, and it's not there. If that contract is to be interpreted under the laws of the state of Texas, the court will not step in and allow you to kind of use other legal principles from the common law. What they will be looking at is whether or not this provision is in your contract. And of course, if you don't have a contract, then you won't have any, that sort of ends full stop. But Texas courts are very specific in how they interpret these clauses. If this were an exercise with a bunch of law students, we would pick this apart. There's some issues with maybe how this list in this example is actually written out. Due to how, again, Texas courts deal with force majeure. But again, the purpose was to just give you an example. And, on the flip side of this, there was an attorney on the other side who was thinking, like, what's the list of things that are out of your control? Okay, earthquakes, fires, floods. And you can imagine that differs based on where you are. The force majeure clauses in California probably include like mudslides and all sorts of stuff. I suppose in places where there are volcanoes, it might say volcanic eruption, right? Certainly floods and tornadoes and hurricanes are some things that we would care about in, Houston, Dallas, this region. So the list of what shows up in these clauses is interesting and could vary by region just based on the types of things that they have to deal with. But this issue of epidemic versus pandemic, there's a lot of discussion around it right now. So, I just put this graphic here to represent maybe some of how we are all feeling right now. Again, there are some people who are looking at their contracts, this clause is not there, and so they're like, what do we do? And then some people, the clause is there, but trying to sort of weed through it and see whether or not a court would enforce it or whether or not it's worth it to try to get a court to enforce it also results in the same sort of response. So this is, I think, kind of how a lot of us are feeling right now, but these are the types of boring contract terms that deal with the things that we're experiencing right now. So let's switch gears here and let's go through a real life example of the type of situation that's happening in the midst of COVID-19. So when I say real life, I mean, this is an example of a couple different issues that I'm working with clients through, but it's a sort of a mashup of different types of things. But this is actually pretty common. So you have a muralist, right, who is scheduled to paint a mural indoors, and the artist and muralist was to begin painting the mural during a live activation at a hotel. So what we have is someone who is doing a large scale work. They were already scheduled to do this large scale work. They were doing it indoors, meaning in enclosed spaces with other people. And specifically, this muralist was supposed to begin the mural during a marketing or a live activation or an immersive experience at a hotel, which is in the tourism industry, right? So this is like the very thing that this type of situation would be the very thing that would be canceled, if you will, in the midst of COVID. It's at a hotel, so, tourism, we're done, with that for right now. Live activation means there's a bunch of people around, so we can't do that. It's a mural, it's a large scale work that, requires the artist to be on site for a long time. It's indoors, which means that, it's more susceptible to transmission of the COVID virus. So everything that could possibly be COVID-19 related, I tried to come up with a situation that fit. And so the question is, what happens? The event gets canceled, quote, until further notice due to a pandemic. So I underline this until further notice because these are the types of emails, these are the types of calls, messages that my clients are getting where their work is being postponed until further notice, which is very vague and sounds very scary. But this is a quintessential type of thing that people are dealing with in the art world. So let's talk about how you may work through this. So event gets canceled until further notice. And really there's two things, right? Either you have a contract or you don't. Either you have a written contract or you don't. I'll pause here to say that there are such things as oral contracts, and state courts will enforce an oral contract. But the process to enforce an oral contract is very lengthy and costly because you have to rely on rules of evidence and you have to rely on civil procedure in order to even allow the type of testimony that is needed to prove up an oral contract in court. So again, you can enforce an oral contract. Those are all those handshake deals people are making. You can enforce that, but the amount of evidentiary proof and the way that you have to try to enforce that contract in court is costly because of how the rules of evidence and civil procedure work. So back to this slide, either you have a written contract or you don't have a written contract. And so how would you deal with this situation with our muralists? So let's say you have a contract. This is pretty much the process that I'm walking clients through, with clients on a daily basis, and this is what artists are walking through. Well, the first thing you do is you look at the contract terms, right? You go to that sheet of paper that you have that hopefully represents the actual agreement that you came to with the other party. And it's not just some form that you got from Google or online somewhere, but it's an actual contract. Hopefully, well, what you should be doing is looking at that contract and going to the terms in the back, right? The ones that appear before the signature lines and seeing what's there that can help you. So you're looking for force majeure. That's the number one thing. That's why I put it as number one. You're also going to be looking to see if there's any contingency or extension. So that's why I put that as number two. Then from there, you're going to say, okay, well, if there isn't a force majeure and there's no way that I can and there's no contingency built in, well, then how do I get out of this contract? Or is it legal for them to get out of the contract? So you're looking at those termination and those cancellation clauses. So there's sort of a thought process you go to see what's in the contract and how that may be able to assist you. You evaluate the loss and or your risk, right? So you take a step back and say, all right, what is the value of this deal? What are my potential losses? And for artists, they're looking at this at multiple levels, right? So it's not just one event that was canceled, it's all of them. And so now what do? So you have, a series of things that you're looking at, a series of contracts, maybe a series of relationships, and really what we're doing is looking through them, evaluating the losses that could be incurred, that could be dollar amount, that could be represented in materials that were already purchased. Like for the mural example, if you've already purchased materials that you can't take back, or purchase supplies and art supplies for commission. So the process is to look at what's there, kind of put it all out on the table, if you will, and then just start evaluating each one individually to see what the potential losses are or see what your risk exposure is. So what is the totality of the damage of what we see here. That can be very depressing and very daunting, I understand. But in terms of just coming up with a game plan for how to manage through this situation, that's the process I'm walking my clients through. Let's look at what's there, put it all out on the table, and evaluate the losses and the potential risk exposure. Then you put them in order of either the heaviest loss first, the least amount of exposure last, and then you go through a process of identifying, different things that you can negotiate, and you communicate with the other party, right? You look at what can be negotiated, you look at what you can do, you come up with ways to either keep the contract going and maybe pushing some things off, or ways that you can negotiate a termination, even if there isn't a termination clause, right? So even if there's the absence of something in the contract, what people are doing now is trying to negotiate and look at the specific deal to see what could be done. So that's if you have a contract. Again, the process is look at the contract terms, put them in order by risk of loss, and however you want to deal with that psychologically. If you want to tackle the small losses first and then deal with the bigger ones, or vice versa, but put them in some sort of order or hierarchy, and then look at them to see what can be negotiated. And you certainly want to try to communicate with the other party. So not just ignore that these things are here, but you want to communicate. So what happens if you don't have a contract? If you don't have a written contract, one of the things that you can do is to go back to your emails, and if not emails, maybe you have text messages that are evidence of your agreement. There are plenty of situations where I'm working with artists and they don't have a written contract. So what do? We go look at emails, and sometimes there aren't even any emails. It's just a series of text messages. And what we're trying to do is look to see if there were any offers, acceptances, and consideration that can be proven up or that are evident in these other forms of communication. Did the other person agree to do something? Did you agree to do something? When was it supposed to be done? So it's essentially the process of piecing together what would be in the contract from emails and text messages. So if you don't have a written contract, you would be looking at these things. You would be looking at your emails, any communications, anything that's sort of written, to see what's there, to see what you can sort of piece together. You still, though, want to communicate with the other party, right? It's not something that you can ignore, but you do want to reach out to them and see what you can negotiate. But the reality is that you have fewer options, especially if you're trying to enforce a contract, right? Especially if you're the one whose work has been canceled. You have fewer options in trying to enforce that or even enter into communications or a negotiation with the other party, because there isn't anything that's written that memorializes the work that you're doing. So you have fewer options, but there are still things that you can do. And I want to just mention this again, because it's now, there are plenty of opportunities to despair with what we're going through right now. And it's not just this, there are a lot of other things that people are dealing with because of COVID-19, and it's multiplied. It's not just you individually, but it could be your partner, it could be, your household, your friends, everyone's affected by this. So I do understand that the mental, the psychological aspect of doing what I'm saying right now is difficult right now. But what I wanted to do is give you information and kind of a path forward, in a way, a framework to think about even how to tackle these sort of issues when it comes to cancellations for artists and businesses and what you can do. But yeah, you're essentially in the contract, no contract bucket. And again, you can enforce an oral contract, but when I say no contract, I mean you don't have a written contract. So again, you're relying on other forms of communication that may exist that would help piece together the terms of your agreement with the other party. So there are a couple of simple ways to protect yourself, and I see a couple of questions coming in. So we're at the last part of the slides here, so I'll answer those in a minute, but these are just some simple ways to protect yourself. You want to get your agreements in writing. So you see here I've shifted from just saying contract, and now I'm just saying get your agreements in writing. And I'm phrasing it this way because I believe that a well-drafted and well-crafted email is a whole lot better than not having anything. So often for the handshake deals that are very prevalent, particularly in the art market, one thing that may be helpful is you have a conversation, you have a meeting at the coffee shop, and then not too long after the meeting, you summarize, right, what you discussed, take your notes, put them in an email, summarize what you discussed, and send it, right? Because now you're creating a record of the agreements, the things that you spoke about. But a well-drafted and well-crafted email can be really important, and the courts will enforce it, right? If it meets, well-drafted means that it actually summarizes in detail what the agreement is. Well-crafted means that it has the elements of a contract, but it's just in an email. So you can do a lot with an email. But yeah, you want to get your agreements in writing. Also, you want to document any scope or project changes. So what that means is, you know, sometimes you may enter into an agreement and then things change. Well, you want to get those changes in writing. I've dealt with a lot of situations where there was actually a pretty robust contract that existed, but the relationship changed and nobody documented the change. So this is like the client asked for something else and then you just do it. You want to document that change, because if something, again, were to go sideways, you want to have a record of that. Number two, you want to negotiate more favorable payment terms. This is a way to preserve cash flow. So when I said that clients are looking at their current policies and procedures, I have some clients who are literally coming up with different ways that they bill, or different ways that they think about their payment terms. So I'll use our muralist again as an example. You know, if in the past you would just do the work, you would paint the mural and then get paid when it's done, might want to think about changing that in this this COVID world, because that can negatively impact your cash flow. Why? You've spent money up front to buy all of the materials, but then you don't get paid back until after the mural is completed. If that were to happen, the situation were to happen, like our example, the muralist is completely out of that money, and it may be that they never get it back because of the way that they set up the payment terms. An alternative would be to set up payment terms in thirds. You get some money up front that could be towards, you know, materials. You get some money while you are, or right as you're completing the mural, and then you get the third of it after it's finished. That's a way to think about how you even set up your payment terms that can preserve cash flow. And so the artists that have contracts where they've done that, they are doing a little bit better than the artists or creatives that don't have payment terms that are in their favor. And real quickly, what I mean by in their favor, I should mention, you know, on any contract, and I'll use my hands to demonstrate this, you have two sides. There could be more parties, but if you and the other party is going to negotiate for things that are in their favor. It doesn't matter if you're best friends or you're collaborators or like you're related. It's still going to be in their favor. And then your job is to negotiate for terms that are in your favor. So what happens is sometimes artists will rely on the feel-good feeling that they have with the other party, like they get along with them, they like them, all of these things. But the contract, when you see the contract, it's very one-sided, and you can see clearly that most of the contract terms are in favor of one party over the other. So what I do is I help sort of balance that out, but you are responsible as the creative or the artist of looking at the payment terms specifically to make sure that they are in your favor. And one of the metrics for that is what types of contracts terms preserve cash flow. You also want to think about your worst case scenario. That's what lawyers do all the time. I know some people consider that to be very negative, but you really do want to think about, okay, what happens if this whole thing just goes sideways? Like the whole thing goes off rails, what do you do? Well, those boring contract clauses, those are the things that, of course, become really important. And to the extent that you can afford it or you can build it into the cost, particularly for our muralists, you can build the cost of insurance into your, commissioned public art project. Insurance is really important. So it goes without saying that a lot of people are also looking at those insurance policies to see if there's something there. There's a such thing even as business continuity insurance, right? It's the insurance that may kick into play when there's something that happens that disrupts the normal course of business. So there's all sorts of insurance that you can purchase, but it is something that to think about, even if it's at a specific event level. And if you have a major project, you definitely want to get help. Major is defined however you think major is defined. Some people think, well, it's not a major project unless it's over $5,000 or $10,000. So they peg it to a dollar amount. Some people think major project is defined as the importance to their career or their interests, right? So you may be doing something for the DMA, the Dallas Museum of Art, and it may only be $1,500, but the opportunity is really significant. So that may be a major project for you. So the thought here is, if you have a major project, you certainly want to try to reach out for help. And the help that I offer and provide is legal help. But there's organizations like Texas Accountants and Lawyers for the Arts. This is a statewide pro bono organization that provides pro bono services to artists and creatives, and it's attorneys and accountants. So there are resources out there in the community. So you just want to think about getting help if it's a major project. And, you know, even if you do all of that, it's not going to solve everything. So it's not like the result will be like a super smiley face. It's just more the grin and bear it kind of face. But at least you won't be if you do these things, at least you won't be in a position where it really feels like everything is shifting very quickly under your feet. There are some things that you can do on the front end to be able to help you kind of deal with some of the things that we're dealing with now. And I just put this slide as one of the last slides. It should go without saying, but I thought I would add it here. What you don't want to do is breach the contract. What does that mean? Breach the contract means that you just say that you're not going to do something, even in the midst of COVID-19. So let me say that again. Even in the midst of COVID-19, you don't want to just not do what you promised to do under an agreement. That would be breach of contract. When you breach the contract, you basically open the door to liability. And the ramifications for that could be beyond what you can think or imagine. So you don't want to breach contracts. There are a lot of ways to modify contracts or get out of contracts. We talked about some of them. We talked about termination. We talked about cancellation, if there's a way to cancel and it not be a significant financial hit. There's also some elements within the common law, meaning court-created law, called frustration of purpose. There's impracticability. You can negotiate a termination even if your termination clause isn't there. You can rescind a contract. You can repudiate a contract. You can revoke a contract. You can even argue that there was a mistake. It's called mutual mistake, or you could try to void a contract. We do not have time to go over all of those things, and those are all different. So the second half of the contract class that I was telling you about for law students talks about those types of principles. But the point is this: there's a bunch of stuff that you can do in the midst of COVID-19 to help you weather what's happening. And there are legal principles that are there that you can avail yourself of. But what you absolutely don't want to do is just breach the contract. You don't just want to go silent and not reach out to the parties on the other side. Most of what we spoke about today, we spoke about it from the perspective of the artists who other people are canceling contracts or canceling events. So it's from the perspective of the artists having their work canceled. But there's a flip side to that, right? There's two sides. There's a flip side. There are artists who are trying to think about, okay, well, how do I get out of this contract? Well, I don't have the money to do X, so I promised to do Y. Can I just not do it? And the answer is no. You don't want to breach the contract. You do want to reach out and start having conversations to see what you can do. So again, don't breach the contract. So moving forward, I self-soothe myself by pulling images of museums and fashion shows and Basel and all sorts of things, discussions, Dallas Art Month, all the things that I'm missing right now. that we're all missing right now in the midst of COVID-19. So I went and like put this collage together to just kind of remind myself of how much I love going to see art and being in these spaces and listening to artists talk about their work. But in terms of moving forward, contracts were important, agreements are important before COVID-19. They are certainly important now. So one couple of things you may think about in the future is if you thought before that contracts are only for, again, artists that are making a certain amount of money, or it's, something that's a nice to have, it's a luxury, it's something that, you just don't really need to have. If that was your thought process before COVID-19, I would offer to you that this circumstance has given us the opportunity to think about things a little bit differently. No matter what you're working on, there is a way to reduce your agreements to something in writing, again, even if it is an email. And certainly if you're doing something that's, a major project, you do want to think about what happens if everything goes awry. Like what happens if something bad happens? How do you terminate a contract? These are things that you can talk to the other party about. How do we get out of this contract? What happens if I can't deliver the service? What happens if you can't pay on time? There's things that you can think about and talk about with the party on the other side. And essentially what you're doing is just planning for the worst case scenario. It doesn't have to be an icky conversation. It doesn't have to be super negative. It's just the responsible thing to do in the midst of dealing with circumstances that are out of your control. So that is the end of the presentation. I think we have some minutes for questions, but I did want to say before I flip the screen back on the share that my only disclaimer is that nothing I said was legal advice. It's information. So, but if you want to get in touch with me, here's my information. You can follow me on IG. I'm at Sammy Iami. That's my personal account, and then Goodson Law. And then, of course, there's my email address if you have any questions, and my website as well. So I will stop the share and flip us over here. And I think I saw some questions that came in the chat.
There's one in the Q&A and there's one in the chat.
Okay, awesome. So let's see, I'll address the chat first. It says, how can you use email as documentation when you don't have a written contract? So the idea is that what the contract really is the result of your conversation with the other party. It's the result of your agreement. So let's say that you have a couple meetings and you decide that you want to do a project where you're going to represent an artist. What you would do is in the email, you would have essentially the same terms that we went over in this presentation. You'll have, the parties, who's doing what are they doing. In this hypothetical, the service you're providing is that you are representing the artist. You're going to represent them for a period of, April 2020 until April 2021. You are going to do X for the artist. You're going to introduce them to collectors. You're going to try to get them in shows. You outline what you're going to do for the artist. You talk about payment. Is it an upfront payment? Is it an hourly payment? Is it flat fee? Is it paid every month? So you want to talk about the terms, how much you're being paid, and then when you're being paid, like the schedule. And then you want to get into, all right, well, what happens if you don't want to represent the artist anymore, or the artist doesn't want you to represent them, right? You start getting into some of these more boring contract terms, which essentially deal with what happens if a relationship is needs to be terminated for whatever reason. So in an email, you take the concept of a contract and you put it in an email, but really what the contract is your agreement. And where people kind of get tripped up is they'll agree to things and everyone says, okay, yeah, that's fine. But then there's never any sort of summary and there's never a written record of it. And that's where issues come up. And then let's see, for the Q&A, it says, is it more common for contracts by the piece of work? Okay, I think the question is it more common to have a contract by each piece of work, or is it better to have a long-term contract when there are multiple works? I'll give you the classic lawyer answer. The answer is it depends. It depends on the relationship. It depends on a lot of things. So some of the things that I would be thinking about are this. If the question is, should it be a short-term individual contracts for multiple projects or a long-term contract, I would be asking questions such as, who's the party on the other side? What do I know about the party on the other side? Do I think it's more likely or not that the party on the other side is going to pay on time? Do I think the other party is going to try to litigate? What do I know about the party? I would ask a lot of questions about the folks on the other side of the contract. Because if you enter into a long-term contract and you have information today that indicates that they might not be a good long-term business partner, if you will, then you should have short individual contracts, because you don't want to enter into a long-term contract and then have to deal with those termination and cancellation clauses if something goes in a different direction. So sometimes it has a lot to do with the party on the other side and what you can find out about them. That's a risk mitigation type of question. Like, what's the risk of this not going correctly? Like, what's the risk of there being a problem? Also, you know, if you're developing a relationship with someone that you think may be long-term, it may be helpful to do a series of short-term contracts up front so that you and the other party can develop a methodology, like a way in which you work with each other. It's kind of like dating. You just sort of do a short-term contracts to see if it's going to work. You might do that for 6 months. And then if it's fine, then you enter into a long-term contract. So that could be a consideration. Let's say I have a client where they have an opportunity to enter into a long-term contract. Let's say the risk of the other party sort of flaking out is really low, but the upside for my client's really high, meaning it's tens of thousands of dollars or it's a really good opportunity. Then that analysis flips. Then you think about, okay, well, it might be a good idea to enter into a long-term contract because the risk of something happening, right, is low. The upside for the artist is high. And if you have a long-term contract, you've now locked yourself into working with or producing work over a year and a half, if you say, and that could be beneficial for the artist. So there isn't it's not a yes or no answer. It's not binary in that way. It's more assessing the risk that something's going to go awry and assessing the upside for the artist to decide whether or not to enter into a long-term contract or whether you should do short-term. The only thing I'd add to that is it's a rare circumstance where I will work with a client to enter into a contract that's exclusive, where there's exclusivity that keeps the artist from doing other work. Those are problematic. They're less problematic when they're short term. They're really problematic when they're long term. So you really have to think about it. If you are presented with some sort of exclusivity clause that keeps you from doing something for a long time, that is a problematic contract term because you literally don't know what'll happen, and you don't want to lock yourself in and have to then sue the other person to get out of the contract legally. All right, let's see. And I have another question here. Is there a way to protect your IP if you're doing an online course that has your created info and artwork? Yes. So you saw on my slides that I have the copyright notice at the bottom of every single one of my slides. Why? It's because when I created this presentation, I had a copyright from the moment I created it. And I put therefore I can put the copyright sign on the presentation. At some point, probably in the end of the summer, I may register all of the copyrights for the presentations that I've done this year. So I'll have a registration for the presentation. Now, the copyright only protects from copying things that are specific, right? So if I were to see my slides find their way on LinkedIn somewhere, that would be copyright infringement. If I saw someone take the idea behind my slides and incorporate it in their slides, that wouldn't technically be copyright infringement, because copyright does not protect ideas. It protects the actual thing that you've created. But your copyright exists from the moment that you create something, and it behooves you to put the copyright notice on it, to put the world on notice. You don't have to, but I just do, because as soon as you see that copyright at Goodson Law, you know that I'm telling you that it's my IP. So that's one way that you can protect yourself. Also, in this presentation, because I know that it's recorded, I chose the photographs that I use very specifically. Every single photograph I use is one that I took. So I did not use any photographs that were taken by someone else where they weren't taking the picture for the purpose of review. So clearly the photographs with me in them, someone else took, but it's a photograph of me, right? And I chose photographs and I displayed them in a way that is less likely to cause issues with any sort of infringement with the images that are behind. I have photographs of paintings. I have photographs of the work that I have collected, but for me to display them in this environment while it's being recorded, even for educational purposes, to me is on the line of it straddles the line of fair use and infringement. So as an IP attorney, I try to model the right behavior for other people. So I've done other presentations that weren't recorded, and I've used other types of images because, you know, if it's for like a class and it's not being recorded and there's not a possibility for it to be disseminated everywhere, then you may choose different pictures. But yeah, so that's what I do to protect IP for online courses. All right, well, I think that's the end of the questions, and we are just 5 minutes over. I'm okay to hang out if anybody has anything else, but yeah, thanks so much for the opportunity. I love talking about this stuff, so I could go on and on about termination clauses and force majeure, but we'll end right now.
Okay, awesome. Well, thank you so much, Sammetria. That was really beneficial. I hope everybody got something out of that. And if you need to go back through the slides, like I said, we'll be giving you the link that you can view the webinar on demand. So thank you and have a good evening.
All right, thanks guys. Have a good one.
Bye.
Stay safe. Bye.